kind indulgence of
Yes.
my lord to item 23, my lord. I came last night, could not lay my hands. I have taken consent from the PP, and Mr. Modi is also not there. So when I kindly accommodate after 4 weeks.
On the prayer of Mr. T.T. Tara, the counsel for the appellate,
Appeal, my lord.
list this matter after
4
4
weeks.
weeks.
Grateful.
May I please, Lordship.
Yes.
Lordship, I'm making this prayer on behalf of SK Singh, Senior Counsel, item number 1, Lordship.
Item number?
1, motion. Yesterday he came here, yes, Lordship, and after filing, he got sudden urgent walk. So by last night only he left. So may I amplify that matter may be listed on 25.
25.
25, Lordship.
This matter is spread forward by Mr. K. Learned Counsel on behalf of Mr.
SK Singh.
SK Singh, Learned Senior Counsel. List this matter on 25.
At motion,
04
motion is
25.
this.
May I, Your Lordship?
Deeply obliged.
Yes.
Item number 22, Your Lordship.
20?
2.
22, yes.
May it be fixed after 2 weeks, Your Lordship.
This is what?
RFA, Your Lordship.
RFA.
I have taken the consent, Your Lordship.
List this matter before any other appropriate rights without me. Not before.
Yes,
me.
Your
May I, my lord?
Oblige, Your Lordship.
My lord, item number 5. I may be allowed to mention on behalf of Mr. B. Kosi.
Huh?
Item number 5.
Yes.
Let this matter may be fixed on 30th of this month.
On the prayer of Mr. T. Omo, Learned Counsel for the appellate, list this matter on 30/04/2025. Yes.
Most.
Yes.
Please, Your Lordship. I would like to mention item number 7.
7.
Yes.
Yes. What do you want? Yes.
Your Lordship, due to some unavoidable domestic issues, the leading counsel is out of the station.
On the ground that leading counsel, Mr. Nalopada
Yes.
and Pada, Learned Counsel for the petitioner is is having personal difficulty. Come on, this matter will be discussed after 2 weeks.
Yes, ma'am.
2 weeks. Item 7. Yes.
My Lordship. Lordship, I beg to mention item 3 on behalf of Mr. S.K. Theory for the petitioner.
Item
Item number 3
3.
on behalf of S.K. Theory for the
SK
petitioner.
Dairy. On the there's what about there was
My lord,
supposed to have-
here, the matter we have already compromised, my lord.
Then
Yes.
I have been instructed to withdraw item 3.
withdraw.
Yes.
Withdraw.
Withdraw.
Okay, withdraw.
Yes, we have compromised.
3 and 4.
No, 4 is different, man.
What is what?
4 is a person, man, but the 3, man, that's in a group, man.
Okay.
Village between brothers, man.
It is submitted by both the Learned Counsel for the petitioner, Mr. So and so, appearing on behalf of Mr. S.K. Dairy, and Mr. P. Tapu, Learned Counsel for the respondents, that the parties have settled the matter outside the court in view of and therefore matter be therefore press that civil division petition be closed, may be closed. In view of the CRP states closed.
Item 4 may be listed after 2 weeks.
Yes, Your Lordship. Item
Closed.
4 may kindly be listed
Yes.
after 2 weeks. 4 weeks.
No,
2 weeks.
state
2 weeks.
closed. Then item 4
It may be listed after 2 weeks.
on the prayer as prayed for the Learned Counsel party. List this matter after 3 weeks. 2 weeks, 3 weeks.
2 weeks.
2 weeks.
2 weeks, yes.
Pleadings completed, my lord.
Yeah.
Mr. Deori has requested me, my lord.
Speak.
Obliged.
Your Lordship, I'm on behalf of the petition counsel for the petitioner, G. Kali. Lordship, in the last occasion as well, the opposite party was not present.
Yes.
It may be listed after 3 weeks. The lead counsel is also out of state.
Hmm?
Counsel for the petitioner is out of state.
What's the issue?
So, Lordship, I'm not well versed with the case.
Okay. On the prayer of Mr.
G.
Hmm?
Kali.
You are Jeetalo.
No.
Your name, please. Learned counsel appearing on behalf of Mr. Jeetalo. The counsel could have released this matter after 4 weeks.
May I please, Lord? The case diary was awaited on the last date of hearing, Lord.
Lordship, Siang Taj murder case, Lordship. Siang Taj murder case.
Yes.
On the last occasion, no medical board was constituted
Okay.
and report is there, Lordship. And we received case diary this morning.
You have received the
Yes,
case.
yes.
Yes. What is there?
Since the petitioner was already released from the hospital,
Yeah.
Lordship.
Lord, what did you say? What is
If
the
he's
objection?
already released from the, why there was the question of bail?
No, he has not been released. He's not been released. I was undergoing treatment. Thereafter, Lord, I moved the application while I was in the treatment. And then, Lord, medical board was constituted. And because of the case diary, the matter could not be heard last time.
Second last paragraph, Lordship. It is from Medanta Hospital, Lordship, Medanta Hospital.
No, I have been discharged from the hospital is okay.
Yes, this is from.
Discharged from the
yes,
hospital. Yeah, that's fine.
right.
That's fine. That's fine. I have been discharged. I have been discharged.
Yes, what about the medical board?
Medical board has confirmed my being admitted there in the
Where is the
hospital.
medical- Where is the medical board?
In the court file, Lordship.
Huh?
Report is on the record of
Court file, Lordship.
record, Lord.
Where is it?
Status report.
Hmm?
That one is status
Yeah.
report. No, in the main file, Lordship. The flag one, Lordship.
Okay. Yes. What do you say?
Yes, my lord. So, my lord, my case was that luckily I am before the same bench, my lord, which has rejected my earlier bail. This is the second anticipatory bail, my lord. That time, my lord, unfortunately, the entire record of concerning the medical was not before my lord. And my lord, that time, my lord, investigation was at the initial stage. So, my lord had formed the opinion that there is something prima facie existing against me, and therefore no bail at that time. But my lord, lot of water has drawn down the bridge, my lord. After that, what charge sheet has been filed. Roles of all the accused have been clearly delineated in the charge sheet. There is nothing against me in the charge sheet. Only thing which was attributed then and now remains that I had received 3 missed calls. Nothing more. Since it was the initial stage, so my lord was pleased to dismiss my bail application, and it was done rightly so because it was at the initial stage, my lord. But now, my lord, when the charge sheet is there, Lord, may I pass on the charge sheet copy? And there are certain remarks in charge sheet, my lord, which favor me.
Yes.
My lord has it. First of all, my lord, I have not evaded the arrest. This IO himself is remarking about me. My lord can have page 9 of charge sheet, my lord. IO was aware about my medical condition. The medical board which was constituted has confirmed my medical condition. My lord, I was in a very bad shape in Guwahati, and then I was airlifted to Max Saket, and I have undergone an extensive medical treatment, my lord. So, if my lord may allow, page 9 in the middle, my lord, the accused Ashing Lagu was not issued NBW because he was undergoing medical treatment in Delhi, which was in my knowledge. This is what the IO is saying.
Where it is?
My lord, page 9
Of what?
of I have paginated this, so my pagination should be running page 9, my lord. Page 9, my lord. If my lord have the middle of the page, the accused Ashing Lambu was not issued NBW. My lord has this. Accused Ashing Lambu was not issued NBWs. In the middle of, my lord. First para, somewhere in the middle, my lord. Because he was undergoing medical treatment in Delhi, which was in my knowledge, my lord. So, factum of my being under the medical treatment, my lord, has been confirmed by the board and as also by the IO in the report, which he has filed before the court. My lord has this. Subsequently, and subsequent things are not relevant for me. And then, my lord,
But you were absconding and evading arrest.
no
You're
charge of
telling me. Yes.
no.
No, it's included. Bail of accused serving so and so and so, Ashing Lambu and Tungdu were rejected by the
No charge. No, I was
then all of them were absconding and evading arrest.
no, Lord. Have I shown this page 9, my lord?
Anyway,
My lord,
charge sheet has been filed.
filed, and no role has been attributed.
To those who was arrested, Lordship. And the IO framed for supplementary charge sheet.
It's okay, supplementary charge in what? How can you file a charge sheet
The applicant is
only against the
the applicant is
Lord, can I be allowed?
his sole ground for this anticipated bail is only on medical ground, and medical report is their Lordship. He was discharged from medical, and advice was to follow up the check-up only, Lordship.
If there is a change in circumstance, my lord, I can break up that change also. It's a well-settled law. And now there's a change in circumstance. Everything is out in open. If my lord allow me, my lord, there are 13 accused people. You implicated left, right, center, the whole family, out of which only 5, it is 5 people against whom the charge sheet has been filed. Rest of them have been excluded by the IO himself. Can I take my lord to the
Yes, he is correct. No charge sheet against you.
No, I'm not on that. My lord. I'm somewhere else. My lord, what I'm submitting, my lord, is that you implicated the whole family. And whole family joined the investigation in one way or the other. Some were arrested, some joined after they were given in anticipatory bail. You have everything with you. And so far as I'm concerned, you had 3 missed calls against me then, and you have 3 missed calls against me then now.
Arrest is required.
Yes, actually, this is the question.
Earlier, he was on interim bail, but he was not cooperating. So his
Well,
bail was rejected.
This is very
Lordship.
unfair. This is very unfair because look, I was when I was on bail,
You have been released on
interim bail, and I joined the investigation. I got my statement recorded. So what, from where my friend is stating, well, I don't know. Can he show the case diary that I have not been cooperating?
it's there.
No, but
The charge sheet is says
during investigation, my lord, under my lord's order, this court itself, my lord, I joined the investigation. I got my
investigation cannot be a one-day affair.
my lord, then my lord, I got admitted, and my lord, I can be put on interim again. I will join till whatever time my friend
Whatever
wants.
the arrested
Yes.
persons, have they been released? Since the charge sheet has already been filed.
Yes.
What is the status of whatever?
Your lordships, for regular
Eight of them-
bail was granted to one. The
8 of them
Supreme-
have been even excluded.
Is for whom?
My lord, I am for the complainant. The
Lordship,
Supreme Court has
interrupted.
granted notice. The
Without
Supreme
authority, my
Court
lord, he
has-
keeps interrupting without authority. He has no
I
authority
am
to
for the
speak,
com-
but he still
Yeah,
keeps
I am for
on
the complainant. I have
submitting.
challenged. My lord, I have to inform the court of a Supreme Court order.
What new
I
thing
am
you're
an officer of the
informing
court.
about?
Yes. So let me finish and I'll explain.
He's
the
not
court.
allowing the court to function.
Tabing, your lordships, allow me to inform the court of a Supreme Court order. Tabing Lamgu was granted regular bail. The Supreme Court had issued notice and asked Tabing Lamgu to be physically present on the next date of hearing. The state will verify this. We have served a copy of this on the state. There is, unfortunately, even medical reports are under a cloud in this case. Tabing Lamgu's case, my lord, the Supreme Court is duty from the Supreme Court has asked a person released by the Honorable High Court on medical bail to be physically present. That order, my lord, is with the state. It is uploaded on the Supreme Court website. It can be taken up. I just wanted to inform the court of this. As an officer of the court, it
If
is
he's through with his submission, good. Can we continue with the case? Are you through with the submission, or you want to submit something more? Tell something new about me. What is my role? If you are representing complainant, tell about me. How I am wanted for
entire
the
conspiracy.
how I am wanted for the
has-
how I am wanted for the custodial interrogation. This is a question of custodial interrogation.
The
What do you want from me?
The conspiracy has in the house of the petition. That is what the plan says.
Kindly
The
go on
entire
the
conspiracy
conspiracy.
was hacked in his house.
Go on the conspiracy. How you find
So
me
we need
Just wait.
in murder.
Just wait, sir. Yes, do you have the medical report, board's report?
Medical report, yes, my lord. My lord, I have filed entire record pertaining to my condition, my lord, and I can give the summary gist of what I'm into, my lord, currently.
No, I'm asking, do you have you gone through the medical report?
I have gone through, my lord.
What it says, last para, in order to give opinion.
My lord,
Do you have the copy of the medical report?
no, my lord, I'm not. I'm not prepared. I gathered whatever little I could gather from the court order itself, my lord. Medical report is on the line which I have.
Yes, earlier bail application was also on medical ground. First bail application.
No, my lord. Medical thing was not discussed at all. I have the impugn order, my lord, before me. It was not discussed. It was not even raked up. Although some documents were filed in the bail application, but it was not raked up before my lord. And my lord only heard the bail application that time, my lord. Finding of my lord is at page 5, my lord. It was nowhere the part of the consideration, lord.
Yes, what does Gezari says? Anything, any specific, just like the. Yes, anything against him? Whether he has been interrogated or not?
Earlier on interview, he was interrogated, but he was denied that the three number.
How can you ask them to, how can you expect them to
Admit.
admit it? It's not an issue. Issue is whether any materials against him, apart from his denial and.
May I take you to the page number 95 of the petition, Lordship? Because the FIR, Lordship.
90,
Since he is absconding, Lordship,
95 of what? 95 of what?
FIR, Lordship.
Yes,
Second for Lordship.
yes.
It is done from the relevant sources that the conspiracy meeting of the late Munjan Lambu family was held at the residence of Sri the applicant Lordship, resident Lordship.
So now you have filed a charge sheet. What more you have? I mean, of course, again, not against this.
But if I can be allowed.
So this is an FIR.
Yeah.
Then now you have filed a charge sheet.
After
against
filing of
the
charge sheet,
other-
he's-
Just wait,
Well,
please.
sorry.
You filed a charge sheet. You have already filed a charge sheet against other. I mean, the co-accused. Anything? I just wanted to know anything. Any material against this present applicant,
In the special, there is nothing, Lordship, just please the.
except saying that there is no, he has evaded arrest.
Yes, Lordship.
So you, according to you, the no charge sheet can be filed unless the accused is arrested, even if he's been interrogated. Is it so? Is it so?
He's not cooperating, Lordship.
No, it's not simply saying we have directed him to appear before you, before the IO, and he has been interrogated. What more you want? You said in your objection, by the police, what they are saying that until that time you are keeping, you have not filed a charge sheet against the present applicant accused, just because until the time he is arrested. What do you want to do by arresting him when you have already filed a charge sheet against the other co-accused?
'Cause, 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 '
why you have not filed a charge sheet against him, despite investigated the entire matter and interrogated the accused. What you have said is,
Is there in the,
huh?
what is there in the report? Lord Chief? What is the Lord Chief? There is your medical board was proceeded, so I also led to the question of this about. Question of this,
Yes. What do you say?
Lord Chief, in the last paragraph, the SFS report.
Huh?
Last line of the SFS report. Lord Chief.
What does it say?
Since medical board,
Not for setting up a medical board of doctors who suggest on his medical condition and decide on his bail application. Huh? Are you directing us? Yes.
not exactly detecting Lord Chief, but since medical report is there, Lord Chief.
No, it's
Well-
not, it's more than the medical, the problem is already established. When he has been released, I mean discharged from the hospital, there's no issue now. And his ailment is also confirmed. Except saying that the treating doctor has to, I mean, properly examine and meet the report. And there's a board was constituted by that Max Hospital. Now, see why he should be arrested. You see, no, don't leave it to me. You give your, or you tell us whatever you say, we'll record it. Eight 4/2025. Church against the accused have been number sciences have been committed a threat to silence supplement. Asim Lambu. Yes, with a prayer to file charge sheet after the After the arrest of Asing Lambu, as he undergoes medical at present, you have prayed you have in the charge sheet you have said that you have prayed for filing supplementary charge sheet after the accused's arrest. Why arrest is required? You have investigated for months, days together, and you have filed a charge sheet against some other co-accused. Why arrest? That too, he has already been interrogated. What is your intention? I mean, the IO. So when you arrest,
There is something to undertake, Lordship.
what? Show us from the material. What something?
The caller, Lordship, the unknown caller.
Because the accused party had intent, planning, and deliberate for committing the crime. Therefore, prima facie charges is found well listed against so and so, 1, 2, 3, 4, 5. How many accused?
13 in total, and 8 have not been even charge sheeted. And those 8 are of my nature, my lord, which they allege they are the conspirators. They have alleged against me also that I am a conspirator. The same allegations were leveled against 8 more who have not been even charge sheeted. Because no material came on the record, my lord. It is on the record, my lord.
Why is arrest is required?
I was not missing that. I was not missing that. Nothing is there in the report, Lordship. Why he is got that.
So,
To be honest, Lordship.
what is to be done? What is this statement
Of, my lord,
of the accused?
must be with them, my lord.
Why not? Apart from this is of the 28/12/2024. Thereafter, any other statement when he appeared?
During the relief period, Lord, yes.
Huh?
During relief period, when I had the relief from the Honorable Court, that time only.
This is only 28/12 only you have appeared.
Once only. They called me once, I appeared once. Had they called me more, I would have gone more. Because they had nothing more to be asked from me, my Lord.
Yes,
My lord, my only
Mr.
submission is,
Tewari.
my only submission is, in this case, my lord, there are allegations that another co-accused had approached a vulnerable witness. Tabing Lamgu had approached Apu Dada. There are allegations that medical records are not what they seem to be. The Supreme Court is looking into it. This present petitioner has had his bail dismissed on merits. He came on medical grounds. As of today, there are no medical grounds. There is a clear report from the Delhi hospital that he is discharged. So my most humble submission would be that he'll have to go to the Supreme Court if he wants to re-agitate merits. This petition was filed only on medical. So it must be decided only on medical.
Thank you.
That is my submission.
And you are not, I'm not supposed to hear you. Are we supposed to
I can
hear
only,
you? Are we supposed to hear
my
you?
lord, I can only make a request, my lord.
This is the
As a counsel for the complainant.
Judgment of our own High Court, which says, my Lord, I can be heard on any number of grounds in my subsequent application.
Hmm?
This is our own High Court, which says that I can rake up any number of grounds in my second application. This court's powers cannot be fettered by on the lines which my friend is suggesting.
What about what about the matters pending before the FX court? With some other, with what he's mentioning. Some petitions are pending before the Honorable Supreme Court.
My lord, Tabing
Can I ask
Lamgu's regular bail, my lord, I can give the SLP number.
You have challenged the regular bail.
Yes, my lord, a notice has been issued.
It's all right.
Some other accused, some other accused.
Yes.
Some other accused, same FIR, some other accused.
Okay.
And he is not being alleged to be conspirator. He is alleged to be the doer of the things.
Hmm?
Allegation against me is the conspiracy. And the man he's talking about, my friend is talking about, is someone who is the committer of the crime. My role can be put at par with those who have been dropped by the IO. The fact of the matter today is that they have been dropped. Even I am also going to be dropped. No charge sheet is going to come against me based on the material which they have against me now.
Why Tabing Lamgu has been implemented?
Yeah, Tabing Lambu has some other allegation. He has full-fledged allegation of murder against him. He is not the conspirator. And he is on the bail from the Honorable Court after he surrendered before the concerned court.
Kozam Dada is the complainant, informant.
Is the informant.
The bail is the challenge is which regular bail.
Must have. I don't know. I'm not aware. Maybe he has challenged the regular.
Yes,
bail
my lord. Regular bail has been challenged.
Which
Yes,
he
my
has
lord.
Granted by the Sessions Court.
by this Honorable
By
Court.
this honorable court. This honorable.
Okay. Okay.
That has nothing to do with this case, my lord.
No, I know, but then it's out of same matter. Accused are different.
Five,
So many
my lord,
accused.
5 out of the 8 people have got the anticipatory, my lord, from my lord himself. My lord was pleased to grant the.
There's another challenge now.
No, there's no. IO has dropped them, my lord. IO has not even written the charge sheet against them, and I am also one of them. Allegation against me are also quite identical, which they were alleging against them. And informant's advocate will agree with me on that.
You just do you have the copy of the order passed granting bail in this matter?
Yes.
You have,
Right now, I'm not in the system.
which has been challenged in this.
Yes, sir.
You give it to them. We'll pass the order.
I'm good. I'm good.
Just give that. Heard Mr.
Sushil Sharma, my lord.
Sushil
Sharma.
Sharma, learn counsel for them. Accused applicant.
My lord.
And also heard Mr. Deloy, learned public prosecutor for the state. I'll pass the word.
I'm good.
Today, we'll pass. Yes, Mr. PP. Give that copy during the lunch time.
My lord, this is regular bail application, my lord. Prior to filing of this bail application, my lord, the applicant has no
Also, PP, learned probably for this. On the office note that is 21/4/04/2025 discloses that the service report upon respond number 2 is yet to be received back, comma. The Mr. So-and-so enters appearance on behalf of the respond number 2. Therefore, service is completed. Mr. Call for the scanned copy of the trial court record. List after.
My lord, may kindly fix it, it on 1 March, sorry, May, sorry, this is
List on
first May,
05/20. Will it be? From where? Pasigat,
from SEPA.
Sepa.
It's only 4 hours journey, my lord,
It's up to you.
on
Okay.
1st of May.
My lord, the office note says that neither TCR nor your lordship, the service has been completed. This is a POXO matter.
What is to be done?
Wait for the your lordship service report along with the your lordship direction to the registry to send a reminder, your lordship.
Neither the service report upon the respond number 2 has been received back, nor the scanned copy of the TCR is received. In view of this matter, after, we'll make it 2 weeks. It's from Changla.
Yes, your lordship.
Long being.
Long day, whatever.
My lord, nature of case is like, my lord. Already, my lord.
The
Urgency.
list on, list after a week.
1 week.
After a week, your lordship.
After a week, registry to and reminder
Online.
for a trial court, scan copy of the trial court.
Listen, one.
Have you taken the steps? It has to be routed through the state.
Take it, my lord.
Okay.
Okay, we'll make sure, your lordship.
You ensure that.
Yes, your lordship. Your lordship, now in this case, your lordship has directed us to produce the checklist and checklist here. Yesterday matter. Lordship, this is the checklist. Checklist is the second page. First page is the intimation letter regarding your intimating the accused that he can consult with the counsel. This first page has been given to the accused. The second part has not been given to the accused, your lordship. The issue was regarding your lordship ground of arrest, your lordship. So the checklist, no doubt, your lordship, which indicate why the ground for your lordship is arrest to prevent such person from committing any further offense, for proper investigation of the offense, to prevent such person from causing the evidence of offense to disappear or tampering with such evidence in any manner, to prevent such person from making any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact of the court to the police officer. As unless such person is arrested, his presence in the court whenever required cannot be ensured, your lordship. But however, Your Lordship, this checklist was not communicated to the accused, Your Lordship. The checklist was maintained in light of the direction given in the Arnesh Kumar case, Your Lordship.
So this has to be communicated.
Yes, this has to be communicated. But in other cases, Your Lordship, today in other cases, we have received the case that is there, Your Lordship, ground of and reason of arrest are there. In this case, is missing, Your Lordship. Even in arrest memo, Your Lordship.
Is this checklist is required to be communicated?
Your Lordship, actually the checklist is required for the purpose of Arnesh Kumar judgment. However, Your Lordship, if this checklist is furnished to the accused, then the ground of arrest inference can be drawn from the checklist itself that what was the ground and reason for his arrest, Your Lordship.
Otherwise, the memo of arrest has to be shown.
Yes.
The ground of arrest.
Yes, in arrest memo itself or the other, Your Lordship, the annexure also, in a part of the arrest memo, that ground has to be communicated, Your Lordship. But in other format, Your Lordship, the ground and reason of arrest is there in the other arrest memo. In other case, I will show
So
you.
no separate checklist
Is not required, Your Lordship.
Okay, heard Mr. J. Learned Counsel for the applicant. Why so many judgment?
There were two coordinate judgments
Huh?
passed by this honorable court, my lord, in respect to the similar issue, relying upon the judgment of honorable Supreme Court. That is the reason, my lord, I have placed it.
And Mr. Swenson, will allow, will grant bail. All right,
Yes, Your Lordship.
21C. Huh?
Your Lordship.
21C, 27A, 29 NDPS.
Yes, Your Lordship.
So,
Actually, Your Lordship, rigor is there under section 37. However, Your Lordship, the judgment of the Honorable Supreme Court on the ground of arrest, it clearly says if that part is not followed, then statutory bar will also not operate. That is the difficulty, Your Lordship.
judgment?
Your Bihan, the judgment of Your Lordship, Bihan, yes, Your Lordship, it's in paragraph 21.
Paragraph 21.
Yes. In Bihan Kumar, Your Lordship, para 21, Your Lordship. Last F, Your Lordship. When a violation of Article 22(1) is established, it is duty of the court to forthwith order the release of the accused. That will be a ground to grant bail, even if statutory restriction on the grant to bail exists. The statutory restriction do not affect the power of the court to grant bail when the violation of Article 21 of the Constitution is established.
One informing the person arrested of grounds of arresting. This 482 or 483?
482.
Hmm?
482.
Huh?
482.
483 regular bail, Your Lordship.
The same thing.
Yes.
You mentioned 482. This is in next para. Hard students, huh? And this is an application under section 483 of BNSS 2023. Praying for release of the accused Sri Dhan Sharma in connection with the PS case number 04 of 2025 under section 20 within bracket C bracket close /27 within bracket A bracket close /29 of NDPS Act 1985, who has been arrested on when?
10/1/2025.
Page number 21, Your Lordship. The arrest memo.
10/1/2025. Mr. The next paragraph. And FIR was filed on 10/01/2025 by ASI TD Goiba of the police station. To the effect that at around 9:30 hours from reliable information regarding the movement of suspected smugglers transporting a significant quantity of cannabis. The informant reported that the smugglers were traveling from Kalaktan, West Kameng district in two vehicles heading towards Doimuk via Kalaktan Rupa Sepa Sagali Road. Close. Mr. Upon receiving the information, the SDP of Doimuk along with SI MK Rai, and the informant himself with SI Tagesa, ASI MA Noor, and the police station's ready party immediately proceeded to the said road for interception. Accordingly, two vehicles were successfully intercepted at Sofo village. Namely, Maruti Ertiga, bearing registration number AS02 AG 0992 and what is escort vehicle? Is the name of the vehicle or
No,
the
no.
escort?
No.
They were escorting the other
Okay,
co-accused.
okay.
Your Lordship.
And other vehicle bearing registration number AS32 A8655, page 16, huh? You find out. Mr. The Maruti Ertiga vehicle was found carrying 26 white plastic bags of suspected cannabis, within bracket ganja, weighing total 134.645 kilograms. list of the suspected cannabis ganjas was seized from the driver in the presence of the executive magistrate and the independent witnesses. List of the driver was identified as one Sri Laksan Basumatri. Thereafter, he was taken into custody. The other vehicle bearing registration number is 32A865 was found to be serving as an escort for transporting of suspected cannabis within bracket ganja. The occupants were apprehended. The three occupants, including the present accused, were apprehended. It is stated that all the individuals were suspected to be involved in smuggling of cannabis ganjas, and accordingly, the suspected cannabis within bracket ganjas were seized along with the vehicles listed. Next paragraph. Pursuant to the above FR, a case was registered being NDPS case number 04 of 2025 under section so and so. Huh? The accused was shown to be arrested and the accused was arrested on 10/01/2025 in connection with the above case, police station case. After the arrest, it was remanded.
Yes, ma'am.
Any remand?
Remand order, my lord, I have not annexed. I have not
Yes,
annexed the
no.
remand order.
Okay. Mr. The bail petition was rejected by whom?
By the district and sessions court, my lord, the special court.
Special judge. Next paragraph. The petitioner, the accused moved in bail application before the special judge within bracket NDPS, UPI. However, same was rejected on 28/01/2025. On the ground that the investigation is at the nascent stage and the main accused is yet to be arrested. By filing this present bail application, praying for grant of bail to the accused, namely Dhan Sharma, namely Sri Dhan Sharma, Mr. Jayasri Learned Counsel for the applicant submits that the grounds of arrest of the accused has not been communicated as required to be done under the law. Mr. While referring to the arrest cum inspection memo at Annex 3, Annex is Annex 3 in the bill application, in this application, he submits that there's nothing in the said memo, in the arrest memo, which discloses the grounds of arrest, which is in clear violation of the Article 21, 22(1),
Section 47 of BNSS Act.
Section 47, BNSS
BNSS
2003,
and Article
23, and Article
22(1),
222 within bracket
One.
1 of
Article 22.
bracket clause of the Constitution of India. Therefore, the arrest of the accused is illegal and is entitled to, and accordingly the accused is entitled to be released on bail without surety, without surety. He has, you just give one judgment which the most nearest which you would like to rely. He has placed reliance on the judgment of which
My lord,
which one?
first judgment, Prabir Purkayastha, my lord, Supreme Court.
Huh?
Prabir Purkayastha.
Prabir Purkayastha
Yes, my lord. First judgment.
versus the state within bracket NCT update imported in 2024 8 SEC 2054 to project that what?
Project that, my lord, there has to be a compliance of the statutory provisions under Section 47 of the
To
BNSS.
project that to arrest the person, the provisions of the Act and the Article 22 of the Constitution of India has to be followed. Which this one you have relied?
From
Paragraph?
paragraph 29, my lord. 29, 30, 31.
29,
30, 31.
30, 31.
And from 46 to 53, my lord.
Why so many?
That was the observation, my lord.
Anyway, this is more than enough to project that is a violation of census. Next para. Mr. T. at London additional PP for the state. By placing the case diary,
Yes, Your Lordship.
has fairly submitted that although the arrest memo the was furnished to the furnished, it was furnished.
Arrest memo furnished, Your Lordship.
And arrest memo arrest come inspection memo was furnished to the accused. Accused or the
Accused, Your Lordship. Accused signature is also there, Your Lordship.
accused, the grounds of arrest as required under the law appears to have not been furnished. Mr. Well, relying on the Judgment of, sorry.
Bihan Kumar.
Honorable Supreme Court, in the case of Bihan Kumar
Reported in 2025.
versus State of Haryana and others reported in 2025, SCC online, SC 269. Further, clearly submits that the requirement of informing a person arrested of grounds of arrest is a mandatory requirement under Article 221, 222 within bracket 1 of bracket clause of Constitution of India. The information of the grounds of arrest ought to have been provided to the accused in such a manner that sufficient knowledge of basic facts constituting the grounds is imparted and communicated to the accused person effectively. Mr. Next paragraph. Mr. T. at London Resident People further submits that although in the present case, the offense, the offense alleged against the accused is under section so and so on, the NDPS Act, section 20, 27 and 29, which ought to have been, yes, which ought to have been attracted under the embargo.
Section 37.
Under section
37 of NDPS.
in view of the embargo provided.
Embargo, yes, sir. Under section.
Section 37, come on. In view of the certain position of the law, that when a violation of section 22 within bracket, section 2 within bracket 1 bracket clause of the Constitution is established, come on. That's embargo. On such restriction oblique embargo, statutory restriction or embargo to grant bail shall not preclude the court from granting bail, as the statutory restriction do not affect the power of the court to grant bail when the violation of Article 21 and 22 of the Constitution is established.
If your lordship allow only just one last submission, your lordship. So far as surety is concerned, your lordship, it has been held long time back, your lordship. The Honorable Supreme Court has held that bail is nothing but a surety only, your lordship. So without surety, later on, it will be difficult to compel his presence.
Not saying that.
Okay, your lordship.
No, and we'll record it,
Yes.
whatever it is, so that we remind ourselves. He further submits that. No, please, however, insofar as the surety is concerned,
Yes, your lordship.
come on. He submits that it has been held by the Honorable Supreme Court.
Yes, I have the judgment, your lordship.
That just give the in the case of
In the case of your lordship, it has been reiterated, your lordship, in 2012 9 SCC 446 As Mohammed versus Shivraj Singh alias Lala Babu and another, your lordship.
have you understood? In the case of
As Mohammed
versus
versus Shivraj Singh alias Lala Babu and another.
reported in
2012 9 SCC
9 SCC
446.
446.
Yes, your lordship. In paragraph, your lordship,
To
para 21, Your Lordship.
that the bail is nothing but then
Literal meaning of bail is surety.
the bail is nothing, but the literal meaning of the bail is surety.
Yes, Your Lordship.
Therefore, if this court, Mr. is inclined to grant bail in the facts and circumstances of the present case, comma, a surety has to be
Yes.
provided. Surety has to be provided.
Yes. So as to securing his attendance during the
So as
trial.
to secure the attendance of the accused as the matter relates to offense under NDPS
Yes.
Act 1985. Mr. I have considered the submissions of learned counsel to the parties and also perused the case that as well as the case laws placed on by the learned counsel relied on by the learned counsel for the parties. Next para. The accused next para. When the accused was arrested, no, after the accused were arrested, he was furnished with the arrest cum inspection memo. Mr. Perusal of the arrest cum inspection memo furnished to the petition
Page number 20.
clearly doesn't.
Yes. As well as Your Lordship intimation. As well as the intimation that I
As
provided
well as the intimation.
of arrest under section 47 of BNSS.
Huh?
Intimation of arrest under section 47 of BNSS. This is just an intimation regarding he can.
It's an intimation
Yes.
under section 47
One
of
BNSS.
2023. Clearly does not disclose the grounds of arrest. Stop. And then the please stop. The checklist which is available, which has been sought by this court through the public prosecutor, additional public prosecutor, come on. Although disclose the grounds of arrest in the recorded the grounds of arrest.
Yes.
Come on. Same admittedly has not been furnished to the accused.
Yes.
Next paragraph. The Honorable Supreme Court, in the case of this B.N. Kumar so and so, Supra, has held, which is reproduced as under para 21. This is para 21.
And 33 is the conclusion, Your Lordship, where the direction has been given.
Para 23.
33, Your Lordship. Okay.
That's it in that case. Huh?
Yes, sorry.
33 is in that case.
In that case, Your Lordship, here also the directed to regularly and punctually attend the court, Your Lordship.
We clarified that the finding of this court that the arrest of the accused has been said in the merits of the church, and that will direct.
Yes.
Next para. Para 21, huh? You caught that, huh? Having considered the submissions of the learned counsel for the parties and the materials available on materials available in the case diary, as well as in the light of judgment and order of the Honorable Supreme Court referred to herein above. Come on. I'm of the considered view that the petitioner, the applicant, namely so and so, is entitled to be released on bail
Yes, Your Lordship.
in view of the facts and circumstances as noted above. In the facts and circumstances of the present case, as the police has failed to furnish the grounds of arrest to the petition, the accused, which amounts to violation of the article provisions of the article 22 in bracket 1 of the Constitution of India. Although the allegation, the offense alleged is serious as the same pertains to NDPS list of, in view of list of accordingly, the accused so and so is shall be released on bail on furnishing what surety.
Is given section 91 of BNSS. Is speak about, Your Lordship, personal bond, Your Lordship. When any person of whose appearance or arrest the officer presiding in any court is empowered to issue a summon or warrant is present in such court, such officer may require such person to execute a bond or bail bond for his appearance in such court or any other court to which the case may be transferred for trial.
On furnishing a personal bond.
Yes, sir.
Personal bond.
On his,
On
his
personal bond.
Yes, yes, personal.
List of it is made clear that the release of the accused, the grant of the bail to the accused is only on the ground that in view of the on the ground that the accused was not furnished, has not been furnished with the grounds of arrest in the light of Honorable Supreme Court, in the light of the judgment and order of the Honorable Supreme Court. And any observation made herein above shall not affect the merits of the case, huh? Merits of the case.
Yes, sir.
Right?
Yes, Your Lordship.
It is further directed that the petition, no, it's okay, that's.
Your Lordship, that
You
direction,
say that personal bond.
personal one and appear regularly as and when Your Lordship could. Because later on, Your Lordship.
Direct that.
Yes, Your Lordship. Because Your Lordship, even the Supreme Court has taken note of it, Your Lordship.
It is further directed that the accused so and so shall regularly and punctually attend the court and the the investigating authority and the court as and when called for.
Yes, Your Lordship.
Well, is petition distance allowed and disposed of.
Obliged, Your Lordship.
You just give that judgment.
The judgment.
Copy of judgment.
As Mohammed.
Ask
Obliged.
Muhammad and this.
Vihan. Vihan Kumar is here. Your Lordship.
Bihan is there.
Yeah, yeah.
And what other one is?
Pradeep.
Pradeep. Bihan is here already.
Yes, I have given Your Lordship. I have the extra copy.
We'll continue it to this color. Yes.
Well, this is a anticipated bail application, my lord.
Hmm?
3 days bail application, my lord.
Pre-arrest.
Yes, my lord. My lord, on the 27/3/2025, interim order was passed, my lord. And then, my lord, I have appeared before the IO, my lord, on last Saturday, my lord. Since, my lord, I'm working as a constable and I'm undergoing training at Haryana, my lord. So I could not appear earlier, my lord.
Because it's a UD case. So it's no longer maintainable now. It has not been converted into FIR, Your Lordship.
So,
Before, my lord, I have an apprehension that, my lord, even if it's a UD case, my lord, what if, my lord, since, my lord, I'm praying for this bail, my lord, in connection to the suicide case, my lord, where somebody is dying, my lord. And I was summoned by the IO, my lord. And I had an apprehension that, my lord, I may be arrested, my lord, in connection to the case, my lord. What if, my lord, tomorrow, now they find that I'm not connected with this case, my lord. What if they register a regular case, my lord? I'll have the same apprehension, my lord. Therefore, my lord, I'm humbly praying, my lord, that this and my lord.
then you come back, we'll see. If regular case is, because pre-arrest bail
My lord,
is for non-available offense. No case has been registered
my lord, that's very
against. So we need not provide you withdraw this. We'll give you a liberty
But
to approach again.
But there
In
is
case
a
the
stress
case
from the-
is a regular case is registered. Are there?
But at least some assurance has to be given. Otherwise, my lord,
It's okay, you come back again.
but
Because if it's not maintained, what can we do? We know that part the apprehension, we understand.
my lord,
But the problem is until the time it is, if any valuable, non-valuable offense is registered,
my lord.
it's a question of anticipatory bail. All right. Is it so? Am I correct?
Yes, my lord.
Then-
I had that apprehension because they were issuing summons upon me. my
No,
lord.
no,
Yes,
first part, you have, we agree that you have, there's an apprehension.
my lord.
Now, as on today, he said,
Not registered.
no case has been registered. It's only UD case.
My
Yes,
lord.
UD case.
My lord.
Mr. Opada, learned counsel for the applicant. Submits that in view of the fact that the no regular case has been registered as on today, except the Naharlagun PS UD case number 01/2025 under section 194
194.
BNSS
Yes.
2023. He may be allowed to withdraw this bail application, present bail application with the liberty to approach again if occasion arises. Mr. Theatre London additional PP is present. Next paragraph. Considering the prayer of learned counsel to the applicant and also considering that no regular case has been registered as on today. Come on. Would not say maintain the prayer
Yes.
for withdrawal is accepted. Mr. Accordingly,
Clause.
the bill is, this present bill application stands
Becoming
closed as withdrawn.
Okay.
With a liberty, please to needless to provide that, needless to observe that the applicant would be liberty to approach this court again if the approach, not this court, approach the court if in future, in case necessary, in case approach the court again in case and approach the court again if occasion arises. My lord.
Obliged.
So this was
May it please, Your Lordship. Lordship, I'm
Yes.
appealing virtually in this matter, Your Lordship. This is a regular bail application. Lordship will find the FIR at page number 12, Your Lordship.
Under section?
Under section 105 of the BNS, Your Lordship. Culpable homicide not amounting to murder, Your Lordship.
Any?
Yes, Lord, his statement has been recorded. And is yet to file the charge sheet. Investigation is almost completed, Your Lordship. It's awaited for FSL report, Your Lordship.
So,
otherwise, Your Lordship, today is the 96 days, Your Lordship. The mandatory period has already been over, Your Lordship.
Okay.
Where's the FIR?
At page 12, Your Lordship.
Page 12 or 11?
Lordship, type copy is at page 12, Your Lordship, of my petition. Lordship, if may I read it, Your Lordship? I'm writing this to report an incident that occurred on 19th January 2025 at around 8 a.m. at Vienna village. Sir, a dead body of a local mystery was reported by the accused who were deployed as a Airtel tower fixture at the village. According to the accused statement, the incident happened while they were playing with their air gun when he accidentally pulled the trigger and the gun was loaded, which caused the incident. Therefore, I would like to file a report regarding the incident. Subsequently, on that particular day itself, the petitioner has been arrested, Your Lordship. The very next page, Annexure 2, is the forwarding report, Your Lordship.
What is the connection?
Lordship, otherwise, they were playing with a air gun, Your Lordship. They were
Air gun.
playing with a air gun, Your Lordship.
Air gun.
And
So accidental.
Accidental.
it's an accidental case, Your Lordship. And unfortunately,
any material against the petitioner?
Yeah, he has admitted, Your Lordship. Admitted, Your Lordship.
Admitted?
Yeah, admitted that while playing with the air gun, he accidentally shot the deceased person from the air gun.
The accused?
Yes, Your Lordship.
Accused,
Yes.
yes. Charge sheet has not been filed.
Not filed yet, Your
Even
Lordship.
after
90 days will be the statutory period, Your Lordship.
it has not been filed.
Not filed, Your Lordship.
90 days is over.
over, Your Lordship. Today is the 96th day, Your Lordship.
Pending for FSL only, Your Lordship.
Heard Mr.
G. Bordlo, Lordship.
G. Bordoloi, learned counsel for the applicant, and Mr. T. at the learned additional PP for the state. Next paragraph. This is an application under section 483 of BNSS 2023. Seeking and praying for grant of bail to the accused person, namely, what is this? Pulchand Ali.
Lordship,
Mohammed Raizuddin.
Raizuddin Ahmed, Your
Raizuddin.
Raizuddin, Your Lordship.
Mohammed Raizuddin.
Raizuddin, in connection with Sayangtaja PS case number 01 of 2025 under section 105 of BNS, 2023, who has been arrested on 09.
Lordship,
No.
there's a typographical error on the very first page
That's
of
what
the
I'm
cost
saying.
of.
When it was
He was arrested on 19/1, Your Lordship, on the date of lodging of the
19/1,
FIR.
2025. Please stop. Next paragraph. And the FIR was next paragraph, lodged by one city. Chacho Benia of Benia village in the East Coming district before the police station, a police officer in charge of the Sayangtaja police station, East Coming district, to the effect that on 19/01/2025, at around 8 a.m. at Benia village, a dead body of non-local, what do you call it, mystery? Non-local person was reported by the accused. Was reported. A dead body of non-local person was found as reported by the accused who were deployed as Airtel tower picture at Benia village. The accused means the present accused.
Yes, sir.
Present accused.
Present.
The present accused, the accused had stated that the incident had happened while they were playing with the air gun, when he accidentally pulled the trigger, the gun, loaded air gun, which has caused the incident. Mr. Accordingly, please stop. Pursuant to the case has been registered being PS, PS case number 01 of 2025, number section 105 of BNS 2023. Mr. So-and-so, learned counsel to the applicant submits that. Submits that. The petitioner was arrested on 19/01/2025
And remanded on 20.
and remanded to judicial custody.
Now in judicial custody, Your Lordship.
Remanded on 20/01/2025. And now in judicial custody.
Judicial custody.
Since then, for more than 96 days, and no charge sheet has been filed. And no charge sheet has been filed by the police. The accused applicant is entitled to be released on default bail. Therefore, it prays that the accused person may be released on bail. Next paragraph. CD, do you have the CD?
Yes, I have the CD.
There's nothing.
CD, Your Lordship, he has stated, his statement is there, Your Lordship, and the gun will also seized.
Mr. T at the learned counsel. Submits that the accused has admitted
Yes, Your Lordship.
that when they were playing with the fire gun, accidentally, due to fooling of the accidental fooling of the trigger of the say the air gun, the the air gun, the victim, this is air gun, the incident had happened. Or we'll say due to what? Admitted that the accused admitted they were the accused and the deceased were playing with the playing. And when he accidentally pulled the trigger, a loaded trigger of the loaded air gun, the incident, it has what is exactly the admission?
Your Lordship, here. Here is the statement of the Your Lordship accused.
Accused,
Yes, and gun has been recovered from his possession only. In last page, Your Lordship will find the finding of the doctor, Your Lordship, cause of death. Just recording this.
No, the accused, Mohammed Raizuddin, has admitted that the deceased had handed over the air gun to him and unknowingly no.
Inadvertently.
And having not known that the air gun was loaded, he had accidentally pulled the trigger, which has hit the deceased left-sided Sahidul Khan.
Last page, Your Lordship.
What is this?
Last page. Mid para, Your Lordship. Now I received the postmortem report.
Hmm?
Last middle paragraph. Now I received the
To avoid
postmortem
the
report.
death due to hemorrhage between the lungs
Death
and-
due to hemorrhage, blood case due to injury to lungs and heart.
He submits that as per the, what is called?
Postmortem report.
Postmortem report. The doctor has appointed the death to be due to hemorrhage within bracket. Blood case bracket was due to injury to lungs and heart by penetrative wound by pellet, PLLA.
And your seizure is also there, Your Lordship. Seizure report is also there. Page number 4 page, Your Lordship. I have not done the pagination.
And the
4 page.
air gun has also been seized from the accused.
Yes, Your Lordship. Column 6.
He submits that the charge sheet, admittedly, charge sheet has not been filed, however, same is due to
Want of FSL.
FSL examination report.
Yes, from Guwahati, Assam.
Having considered that, consider the submission of land counsel for the purpose, and also perusal of the case that it is noticed that the petitioner was arrested on 19/01/2025 and is still in judicial custody since then for more than 90 days.
Yes.
Yes. Admittedly, no charge sheet has been laid as in today. Yes. In view of the above,
Yes.
I'm of the considered view that the accused is entitled to be released on default bail. Mr. As the offense is under section 10
105, Your Lordship.
105 of
Yes,
BNS
BNS.
2023. Accordingly, it is directed that the petitioner shall be, the applicant, namely, the accused, namely Mohammed Raizuddin, shall be released on bail. Then,
Your Lordship, surety to the satisfaction of the learned,
furnishing
investigation authority, since it's under investigation. Your Lordship.
furnishing surety
Yes, surety.
to the satisfaction of the investigating authority. Bail application instance allowed and disposed.
Bail bond amount, Your Lordship. Bail bond amount.
Bail bond,
Yes, Your Lordship.
default bail bond. will be
Yes, is
expired.
Your Lordship.
Then in that case, on furnishing the bail bond of rupees 15,000. 15,000. Bail bond of rupees 15,000.
Lordship.
Security of like him, with one security of like him,
Yes.
to the
Lodge.
satisfaction of students.
Right. Oblige.
Much obliged, Lordship.
15 billion. Yes,
My lord, sorry, your lordship, for correction, your lordship, since he's in judicial custody, to the satisfaction of the concerned magistrate, your lordship.
the inspection of the judicial magistrate.
Yes,
SEPA or Sanctaja or something.
your lordship, it's in CGM SEPA is coming.
The judicial magistrate.
Oblige.
Yes,
Yes, my lord, this is regular second appeal, my lord.
civil service report. Heard Mr. D. Counsel for Deputy. Appellant.
Yes, my lord.
Award service report, list after 4 weeks.
My lord, the interim may be continued, my lord.
Interim order passed, earliest will continue.
This one is also a regular past appeal, my lord. Where challenging the judgment and order passed by,
It's complete.
it seems that my lord is
Service is
my lord.
complete or what?
It seems, my lord, because the other party, my lord, they
entered
they have seem to engage lawyer, my lord. Or PG, the police, my lord. You can see that.
Note is still written during. He's in it. He's in the entire appearance. He had prayed for filing vocal number. Okay. Vocal number is in file. Okay. Heard Mr. The Complainant Counsel for the appellant, non-APS for the respondent. List for admission in after 3 weeks. 3 weeks.
Yes, my lord.
Is the interim
Yes,
order?
yes, my lord.
Interim order earlier was in continue.
Much obliged.
What is this?
My lord, this is a criminal appeal against conviction.
Hmm?
In this case, all the process has been completed. Paperwork has been furnished to all
Also
the
matter.
special matters.
And
legally
admitted also.
Not
There has been
admitted, not
admitted.
admitted yet.
Huh?
Matter may be admitted and.
Perhaps admitted, without admission, your lordship, TCR, perhaps admitted, your lordship. It was admitted in 28/1/2025, your lordship. 28/1/2025.
Admitted already.
Yes, your lordship. And respondent one also entered appearance through a legal aid counsel has been appointed. Today she is absent, your lordship.
But Mr. Yes, he done counsel for the appellant and also Mr. T had done an additional PP for the state. No, legal aid counsel is not present, Mr. The criminal appeal has already been admitted, Mr. According to list for hearing, after 3 weeks, 2 weeks,
2 weeks, not
2 weeks.
for hearing. Obliged.
Oblige, your lordship.
Your service report. Are you appearing
Yes, your lordship.
for respondent?
No, I'm for the petitioner.
Petitioner. Mr. Sir, heard Mr. Sir and counsel. For the petitioner. Okay. Heard. Please, your name, please.
Nabam Ruza, N Ruza,
Nabam Ruza.
N Ruza. Yes, your lordship.
Nabam Ruza.
Yes, your lordship.
Heard Mr. Nabam Ruza and counsel for the petitioner. Award service report. Award service report list after 4 weeks.
Oblige.
Yes,
Lordship, steps have been taken.
yes. How many respondents? Two. Only
Yes,
two.
Lordship.
You are appearing.
Yes.
So this is what?
This is
They are challenging the condoning order.
Hmm?
They are challenging the order which is condoned by condoning.
The
check
delay.
condon
Yes,
the CGM.
Yes. What is the ground? Why it cannot be condoned?
Lordship, can it be fixed on next week?
Having had the learned counsel, the biggest notation, this court is found the appeal spell will be within limitation. Is the limitation run from which can. Okay. So there's no delay, in fact.
Yes, Lordship.
There's no delay, in fact.
Lordship, there's 21 days of delay, which has
There
been,
was a condemnation of delay.
Yes.
When application was filed.
Yes.
But then court found that there's no delay. It is from the date of receipt of the
Certified.
certified copy. Yeah. So, but I was there. You fight it out there on merit. Yes.
Lordship, there's also an interim.
We'll vacate it. We'll dispose of the matter.
Lordship, can
We'll
it be,
dispose of the matter. When the limitation starts running,
Sir, Lordship,
from which day the limitation would run?
after the course of action?
Huh?
After the course of action?
No, in this case, this is an appeal.
Yes, Lordship.
Appeal is within 30 days.
Yes.
If it is within 30 days, when it is from the date of receipt of the certified copy,
Yes, Lordship.
when the certified copy was received.
It's 12-2.
So what is to be done? Dismiss.
No, Lordship.
When? Why?
On 20.
For next week, sir.
There is nothing. Tomorrow.
Tomorrow.
You prepared tonight. Anyway, heard Miss MS so-and-so, learned counsel for the petitioner. Your name is there.
Yes, Lordship. Yasmin Gao.
Okay. MS Yasmin Gao, learned counsel for the petitioner. Mr.
T. Kamji.
T. Kamsi, learned counsel for the learned counsel enters appearance on behalf of the respondents. List for admission hearing on
29.
25.
29.
25.
Okay, 2021.
Okay, 29. You prepare, huh?
Okay, Lordship. Apply.
29.
Okay. Much.
0425.
May I please, Lordship?
Yes.
Lordship, this item is supposed to be in the admission, this is regular bail application. This is in connection with Lordship, TST case. Is the fact is ever by your Lordship that filing of fake IT false input tax credit. Now, here, Lordship, the accused was, in fact, two cases were registered by two investigation. By one, the regular Itanagar PS case, and another is by the.
It's a regular bail.
Yes, regular bail.
So what is to be done?
Lordship, here my ground is, since the charge sheet has already been filed, so further custodial interrogation of the accused person is not required. It was already filed on 3rd of this month, Lordship.
When you were arrested?
Lordship.
When you were arrested? When you were arrested?
I was arrested, Lordship, what happened? In Itanagar PS case number, I was arrested on 28 December 2024. Thereafter, after more than 2 months, while I was in the judicial custody in Itanagar PS case number. Now GST authority, they filed an application before the learned CGM on 3 February 2025, seeking permission for a son arrest, my arrest in their GST case. Now, technically, my arrest in this GST case has to be count from the 3 February lordship. Now it's been 78 days in GST case.
This case only charge sheet has been filed.
Yes.
Yes.
Okay. Charge sheet has been filed.
Lordship, we got the custodial interrogation through police only, because it's very difficult to, we tried many times as per their bail application record also.
Secure the attendance.
Yes, because things that he is the man alleged accused.
What is the trial? What is the stage of trial?
Trial in the sense it's charge sheet has been filed on 3rd of this April only. Now it's supposed to be commenced. Now matter has been endorsed to the JMFC by the learned CGM. So JMFC is the jurisdictional magistrate to try the case as per the CGST section 134. So
you apply bail before the JMFC?
I have already applied, that has been rejected lordship.
No, after the
yes, after filing of charge sheet.
So
yes, lordship, I made a
so what is the will provide them some
yes, with strict terms and
conditions will provide.
Lordship, since as per the provision, we were supposed to file the charge sheet within 60 days, and we filed. But subsequent, there are 58 firms, proprietor, they have been summoned. And this person is the man alleged accused.
No, it's okay, but then you have filed a charge sheet in the case against the accused.
Yes.
With an accused. So
okay, then Lordship, if bail is granted, then strict terms and condition may be. Like, since he's the person, because it's very difficult to get the attendance of this person because he has 2 addresses. One is in Kolkata, and sometime he ran away to Bangalore, then Delhi, then Noida, then again Darbhanga, Bihar. So it's very difficult.
any records? Record is there? Scan copy alert circular along with criminal complaint case received from JMFC.
Yes, we are just concerned about his attendance.
So what
attendance
what condition you want? What condition you want?
Condition, if this honorable court lordship is convinced, then condition may be as there is required of local security. Especially
local security would be lordship.
Otherwise, it will be very difficult to get the attendance.
We'll take it up tomorrow. As agreed to by learned counsel for the parties, list this matter. Agreed to the
I have one judgment after filing of charge sheet, lordship, the custodial not required.
And counsel for the parties, list this matter on 23. Tomorrow, we'll take it up tomorrow. We'll dispose of it tomorrow. I'll look into the record. All right.
That's it.
Now, just bail condition is only, otherwise.
Huh?
Bail condition is
you said bail condition.
Yes. And
he said he'll not be able to provide local security.
Otherwise, as per the expressly record in 182 ita PS case also, it's very difficult because it's very difficult to get his attendance.
So you argue on this matter.
Okay, Lordship.
Forget about others.
Even in 2 bail application, the accused had been granted bail, but without local security, because it will be very
The
difficult.
problem is
And
that
there is
your attendance will be difficult.
yeah, attendance
from
lordship.
UP.
Lordship, yes, lordship.
No,
And
Lordship Bihar, they have different
Bihar.
address.
Yes.
And they had been operating.
No, we're not concerned about that. We're
Yes.
concerned how many people. Only one accused here.
Just one accused.
Yes.
Yes.
We're not concerned about others.
No, he is only the main accused.
Yeah.
He is the person who has been operating and everything. As per the charge sheet, everything is on record.
Okay,
Yes,
heard
yes,
Mr.
yes, it has been filed.
Heard Mr. K. Learned counsel for the applicant. And also heard Mr.
Mr. T. Kipa, Tanya Kipa.
T. Keeper, learned counsel for
CGST.
No. Anyway,
Still is pro forma party.
for CGST,
Yes, Lordship.
CGST,
Yeah.
no, for respondent number
One.
and Mr. Theatre, then the additional PP for the state. Then is for respondent number 2. Next para. This is an application under section. Why 187.3?
187, Lordship, it was for the default, but
Will not.
I dropped this, yes, Lord.
This is an application under section 483
483, Lord.
of BNSS 2023 for praying for grant of bail to the accused person, namely Sri Asutosh Kumar Jha,
Lordship, Lordship.
who has been arrested by the Inspector, CGST and CX, Eternal Commissioner on 03/02/2025 under section 69 of CGST Act 2017 in connection with the alert circular 01/24/225 under section 1 phase 2, huh? Your arrest is arises out of this complaint case.
No, Lordship.
You have been already, you are already in custody.
Yes.
In connection with the complaint case.
No, in Itanagar PS case.
Okay.
That's GR case.
GR
Yes,
case.
yes. Where it is?
It is FIR at phase 45, Lordship. Phase 45 is the FIR. And in this connection, I got a default bail.
Earlier, I mean, the first arrest, you have been released on bail.
Released on default bail.
Okay. So now in this case?
Yes, in this case, alert circular case.
Where it is?
Alert circular, Lordship, will find phase 59. This is the application filed by the
59.
respondent number 2 before the CGM seeking son arrest, my physical custody.
Okay.
Page 59 is the application.
Next paragraph. The accused Sri Asutosh Kumar Jha was arrested. Initially arrested on what?
On same, it was, the order was passed on page 3.
No. Before your earlier.
Earlier on 28 February 2024. So 28 December 2024.
28/12/2024.
Yes, Lord.
In connection with
Itanagar PS case number.
Eternal PS case number 182 of 2024.
Yes, Lord.
List of while in custody, while in judicial custody.
Judicial custody.
Well, in judicial custody in the aforesaid in the above case, the what is this?
Alert circular. It is reflected at page 71, top.
71.
Yes, order of the CGM. 59 is the application filed by the respondent to, and 71.
The office of the commissioner has filed an application. It's an alert circular one. What do you call it?
Alert circular.
Alert circular.
1 of 24/25.
On 29/01/2025.
Yes.
Right?
Yes, Lord.
Before the Chief Judicial Magistrate. Capital Complex, UPA, with a praying for sworn arrest and custody of the accused and remand the custody of the accused for 5 days to CGST and CX Eternal Commissionerate. Where is that order of
Order
decision?
71, close, page 71.
Next page. The learned Chief Judicial Magistrate. No, this is JMFC again.
JMFC, yeah, it was filed before the CGM and it was endorsed to the
Please, unendorsed
JMFC.
by the learned Chief Judicial Magistrate to the Judicial Magistrate First Class, Capital Complex, by the order dated 03/02/2025, the learners JMFC has remanded,
Yes.
Remanded the accused on having found that the accused person is alleged to have committed GST fraud. Accordingly, the petitioner has been remanded and is still in judicial custody since then. Although the accused person has been released on bail in connection with the Eternal PS case number 182 of 2024. Next page. Present application is being filed praying for release of the accused person in connection with the LL Circular 01 of 2024 to 2025, which has been remanded to the custody by the Judicial Magistrate, Learned Judicial Magistrate First Class on 03/02/2025. Mr. K. Nolan, counsel for the applicant submits them. Where is the charge sheet? Any charge sheet?
Charge sheet, Lordship. Report has been filed.
Okay.
I have already applied for the CTC, but yet not for.
Submits that. A charge sheet has already been filed against the accused series so and so.
Yes, Asutos.
Before the court, before the learned court on 03/02/04. 03/04/2025. Therefore, no custodial interrogation is required is required. And as such, the petitioner may be the accused person may be released on bail. Next paragraph. Mr. T. Kipa.
Yes, Lordship.
Learned counsel for the commissionerate. GST.
Yes.
GST
Respondent
and
number 1 that will do.
GST and
CGST.
CGST and
That's only.
no, let us see the CGST and CX.
Yes, CGST and CX Commissioner.
Eternal CGST Commissioner submits that since the charge sheet has already been filed against the accused. There may not be any requirement of further custodial interrogation. No, there may not be any requirement of putting the petitioner in the custody.
Accused, not
Accused in the custody. However, since the accused is a native of the state of Bihar, the attendance, his attendance would be difficult to be secured unless a local security in the event of granting the bail to the petitioner is provided. Next one. Having considered submissions of learned counsel for the parties and also perusal of the reports, admittedly, the charge sheet has already been laid before the court on 03/04/2024. Mr. Therefore, Mr. does no custody they would be required. Therefore, there would not be any requirement to put the petitioner, the accused, in the custody. Mr. Accordingly, I'm of the considered with the please in view of the above, I'm of the considered with the accused so and so is entitled to be released on bail. Mr. Accordingly, the accused person, namely, what is the
Asutosh Kumar Jha.
Asutosh Kumar Jha. Will be released on bail in connection with alert
circular.
Error circular 01 of 2024 to 2025. Is it the case? Error
Yeah.
circular.
Yes.
Lordship, yes.
On furnishing a bail bond of rupees. Bail bond will be required.
Bail bond.
Bail bond of rupees 25,000 with one local surety.
Local security, Lordship.
Surety, sir, given then your lordship may give the condition that without the prior permission from the concerned prior.
Yeah.
Okay.
For leaving the jurisdiction.
And in that case,
Even then will be
with
same.
one surety of like amount
Like Emma.
Yes.
on the following conditions.
Ah.
The accused Sri so and so shall not leave the jurisdiction of Itanagar. Jurisdiction of jurisdictional
Magistrate.
shall not leave the jurisdiction of
Lordship, in remaining bail bond, they had imposed 50,000 bail bond amount. Is
then 50,000.
no.
Shall not leave the
Jurisdiction.
Jurisdiction of the concerned
Magistrate.
jurisdiction of judicial magistrate,
Yes.
first class
Yeah.
UPR without prior permission. Please stop. The accused applicant shall appear before the police and
Lordship,
before
not
the
police-
investigating
Yes.
authority as well as court as and when called for.
Yes. For remaining alleged accused, investigation is still going on.
No.
That's why he is required for this
Yes,
to
we said as and when called for.
yes. Yes.
without prior permission.
Yes.
That would be, because we cannot impose
Some,
a condition which is not possible. That is
Lordship.
amounting to rejection.
Yes, yes.
Supreme
Lordship,
Court has said.
yes, there are some FSL document are
Yes,
there,
yes,
so that
I
need to be, yes,
understand.
yeah, that's fine.
Here,
Offense-
offense,
Offense appears to be very serious
Yes.
and
It's digitally recorded.
element of fraud in there.
Yes,
But so far as
Reasonable.
bail is concerned,
yes, Lord.
yes,
deeply obliged, Lord.
Ali obliged.
this portal.
Bye, please.
What is this?
Madam,
Scan copy is yet to be received. Who has to receive?
Your Lordship,
It has to be through the court.
Your Lordship, I have received the, Your Lordship, investigation, CD, case diary, Your Lordship.
Scan copy of the case diary
Yes, I have received, Your Lordship.
is not yet received.
Your Lordship, it should be through PP actually. Perhaps registry, it has maybe directed through registry.
Heard Mr.
T. Tarun.
T. Toru, learned counsel for the petitioners.
Petitioners. Join application.
Although office note dated 21/04/2025 discloses, indicates that scanned copy of the case diary is yet to be received. Mr. T learned recently submits that he has already received the scanned copy of
Original
the,
copy.
the original copy of the case diary. He has received the case diary. In view of the above, list this matter for admission
Admission hearing.
after a week. After a week, is it a hard case or easy case?
This is a family dispute matter only.
Easy case.
Yes. Arising out of dispute between the second wave and third wave.
Okay,
I have 3 waves.
very proud.
Yes.
Only issue is arms is involved, but it's a
Arms is-
licensed arm.
Yeah, I'm not
So if this 2 section goes, then Your Lordship, matter can be interfered. If this section doesn't goes, then it's arms.
You decide if it's easy
very easy case.
for you,
Yes.
we'll decide. If not, we'll list after 3 weeks.
Very easy family dispute, very simple.
But
matter.
arms sector there.
The
Arms Act
arm
is-
license, arm
Arms
license,
Act
it
is
was
there.
used only because of prevent the further injury to the victim. It
Yeah.
was positively used for to prevent the further cause of injury. Because
Okay, when do we want? Admission hearing on? After a week,
as soon as possible,
after a week,
hardly, yes.
after a week.
And yes, okay. After a week, and Your Lordship, we may further directed to retain the or scan case diary.
And then anyway, you retain it. What's
Yes,
that?
because only one for
Yes,
FSL.
ma-
Only for
husband
part
and
of-
wife, you retain it, it's okay.
Yes, okay.
The learned PP to, additional PP to retain the case there.
Yes.
Next week.
And next item is similar matter arising out of same issue.
Cross case, Your Lordship.
Yes,
Counter FIR.
case and
case.
counter case.
But here arms act is not there, but Your Lordship, we have not received the case diary in this case.
Okay, heard Mr. Tito, learned counsel for the petition. Your name is not reflected here as a counsel. Get yourself reflected. I mean, sign the wakalat. Have you signed the wakalat?
Yes, entire record is filed by through my name only and my
It's
Bakla.
a Nabok Taro only. Your name is not recorded.
I will get corrected.
1920, huh?
Yes.
Anyway, I have Mr. Tito, learned counsel for the petitioner. To case that is yet to be received.
Yet to be received in this case, Your Lordship.
Yes. List the matter after 1 week. As per for, let this matter be listed after 1 week. On the next day, then it additional PP to produce the case there.
Yes, both the case together, Your Lordship.
Okay.
Ultimately, Your Lordship, in item number 19, if main case diary is retained, then it will amounting to stay the investigation.
So,
Obliged.
Highly obliged.
no, in that case, we'll say not to retain,
Yes.
to produce The
Updated.
case diary, update case diary on the next day.
Yes, sir. This
In
is,
the first case, na?
yes, item 90.
Instead of retainer, learned additional PP to produce the updated case diary on the next day.
Okay, I will return it.
That will be-
Oblige.
My lord, here the appellant counsel has remained absent since many times.
What is to be done in that case?
Over telephonic, the
What is the offense?
376.
376.
Yes.
What is the ground here? Nothing. No ground.
They challenge the.
So what is saying? What is saying? Have you contacted the lawyer for the appellant?
Yes, I have personally talked to Mr. John Nika, 3 times.
Then what is
Court requires your appearance. So I told him, but he told me that the client has already taken away the writ from his possession. Now he is no more in this case.
So whatever this A Bhattacharjee, SK Dairy,
They are not there again. Their name is there. I personally talked to them. SK Diori also. Bhattacharjee, one Bhattacharjee, A Bhattacharjee here in this. I talked to him. He is not Bhattacharjee in this case. Maybe another Bhattacharjee.
what is to be done?
Because maybe appointed lordship.
Huh?
Maybe
Is it-
the final lordship.
Or should we issue a notice to the appellant? Is in custody.
My lord.
Is in custody.
No. Probe reliable source that he has already released from the jailer.
What is the conviction?
It is 7 years.
7 years.
Yes.
2000. What is that?
On 8/4/2019, he was convicted. 8/4/2019, he was convicted, my lord. 8/4/2019.
Where it is in the
He is convicted for the period of 7 years. Yes.
eight for 2019.
Yes.
Now
Now it is
not
age
but
on today 6 years, 11 days.
why he's been released?
We don't have any information regarding whether he has been released or not.
Somebody told me, I have also not confirmed, but somebody
Then,
told.
Your Lordship, in that case,
Find out.
yes, your direction may be given to Your Lordship, jail authority to give the status report whether he is still in the custody, or not, your lockup or not. And Your Lordship, since in many occasions, since he is not appearing, this court may, Your Lordship, issue notice to the appellant whether he further want to pursue this matter or not, Your Lord.
So many times.
Many
Yes.
times.
Because Your Lordship, the appeal or the revision cannot be dismissed for default. So,
That's the problem.
yes.
Heard Mr.
Yes.
the learned additional PP for the state and Mr. N. Taje.
For
learned
respondent number
counsel
2.
for respondent number 2. It is noticed that on the appellant has not been represented. It has been remained unrepresented since 2019. Mr. It is informed by Mr. N. Taje, learned counsel, that the lawyers shown reflected in the cause list, the cause title, cause list, has intimated to him that they are no longer representing the appellant, Mr. In view of the work, in the
My lord, if Bakalat Nama is filed, then they cannot withdraw just like
yeah,
that.
it's okay, let's see. We're not going through all this thing because it's been A Bhattacharya, SK Deori,
Now it's 6 years, 14 days completed.
6 days.
6 years, 14 days after conviction. From, if we count from 8th day of April. And perhaps, Your Lordship, during the time of investigation, he may have remained in the custody, so
Yes,
that may be
sure,
set
it
off.
may set off also.
Yes. That has to find out.
Considering, we will issue notice to the lawyers also.
Yes, Your Lordship.
Considering the above, consider in view of the in view of the in view of in the above circumstances, comma, notice be issued to the learned counsel appearing learned counsel who has filed the wakalatnama on behalf of the appellant, namely so and so, A Bhattacharya, Mr. SK Dere, Mrs. Jelika, Mr. Somila or MS Somila.
MS
But
Somila.
Junior of
MS
Deori.
Somila. Learned counsel, huh? It is also directed the jail authorities
Yes, Your
of
Lordship.
Julie.
Yes, sir.
Where?
Julie, yes.
Jail authority, Julie, yes.
Julie,
Yes.
Itanagar to place the status of the appellant, appellant,
Detention, yes, sir.
huh?
Appellant detention, Your Lordship, isn't it? Whether it's in detention or not.
Appellant. That's okay.
Yes.
List after
3 weeks, it will
3
take
weeks.
time.
3 weeks.
Okay, Your Lordship.
All right.
Deeply obliged, sir.
Yes.
Yeah, please, Lordship. Lordship, Counsel T. Pangangi is on lax, Lordship, in court number 1.
What is to be done?
So, Lordship,
Today is for what? Why this is fixed for hearing?
For hearing of Lordship, Order 7 Rule 11 application filed
Okay.
by the returned candidate.
Okay, okay. IA 71.
Yes, Lordship.
Yes. We'll see after some time. He's in the legs.
Lordship, if possible, matter may be taken up to tomorrow, Lordship.
Tomorrow.
As per their convenience, since he's experiencing health issue also,
Okay.
I have been told.
As agreed to by learned counsel for the. No. Mr. Togge Daring.
Yes, Lordship.
T. Daring, learned counsel for the applicant. That means the leading counsel, Mr. Deepangi, for the applicant. Public respondent number 1.
Yes, Lordship.
Applicant public respondent number 1 is engaged in other court, engaged in court number 1. Therefore, fresh for listing of the matter on 23
Yes,
for
Lord.
tomorrow.
Yes,
04
Lord.
2025. The prayer not being objected to by Mr. A. Tata, learned counsel for the opposite party oblique election petitioner. Come on. List this matter on 23, so and so. Huh?
I'll put the respondent number 6 for 3 years.
Mr. So and so, learned counsel for A. Menjo,
Yes, sir.
learned counsel for the petitioner. E. Menjo, the learned counsel for the respondent is present.
Obliged.
Okay.
Deeply obliged.
Please, Your Lordship.
Yes. What is the matter?
It is against an order passed by the Honorable District and Session Judge Pasighat,
Saying what?
suspending the order passed by the learned Civil Judge Senior Division.
So,
And what has happened, my lord, in this case is that, my lord, by an order dated, this honorable court was pleased to pass, pleased to suspend the order, interim, as an interim direction, pleased to suspend the order dated 11/2 till the returnable date. What has happened, my lord, is that in this case is that, my lord, there is the respondent before, my lord, is
who is for the respondent? Are you for petitioner?
I am for the respondent.
Then, who is for the petitioner?
Petitioner, my lord, the advocates were there, my lord. My lord, what has happened, my lord, in this case is that, my lord, respondent is having an LPC land, my lord. Thereafter, my lord, the petitioner, my lord, files a complaint.
Sir, you are a respondent. This for hearing. What is the petitioner? He has to start this case.
My lord, they are not appearing, my lord. That is why I am beginning, my lord.
How you can begin?
My lord, we are agreed, my lord.
So,
by the interim order, particularly, my lord, because, my lord, subsequent to the interim order passed by this honorable court, my lord, the DC has passed a order dated 1/4/2025, directing the parties to maintain status quo. Although, my lord, the order passed by this honorable court dated 24/3, my lord, there is no direction as such, my lord.
Where it is?
My lord, may kindly see the order dated 24/3. Thereafter, my lord, kindly see, my lord, this order was passed by the DC, my lord. My lord, the land immediately is in my possession. I am doing agricultural activities over that land. And because of this, my lord, the order passed subsequent to the order of this honorable court, my lord, this 1/4/2025, my lord, the DC has, my lord, passed an order of status quo, my lord. When the court is in session of the issues, my lord, we have, my lord, perishable agricultural items over our land, my lord. Because of this status quo order, my lord, we are not able to enter into our own land.
So,
This is a difficulty, my lord.
the status quo.
Yes, my lord. Although, my lord,
The civil appeal was in your favor. Who has filed the civil appeal?
civil appeal was filed by the petitioner. And, my lord, what the background of this case is that, my lord, a Kebang decision, ex parte Kebang decision was in my favor, my lord. Thereafter, my lord, he filed a civil appeal before the Learned Civil Judge Senior Division. Against that order of the civil judge, my lord, we filed an appeal before the Learned District and Session Judge.
District Session Judge.
Yes.
District and
Thereafter,
Session Judge.
has suspended the order of the Learned Civil Judge Senior Division. And,
The
my lord,
learned civil judge, decision of the learned civil judge is in your favor.
no, that is not, that goes against me.
Okay.
Because of which we filed an appeal before the Learned District and Session Judge,
Yes.
which suspended the order of the Learned Civil Judge. Thereafter, they moved before.
Where is this?
Yes, ma'am.
Where is the interim order?
Yes, ma'am. My lord will kindly come to page 108. And, my lord, kindly come to page 110. May I read, my lord? My lord, my lord, may kindly come to page 110. Third paragraph, my lord, I will read, my lord. For the aforesaid reason, the appellant has asked for interference. I have gone through the order dated so and so. The order itself revealed that caveat was already in place and status quo order was.
Sorry.
and status quo order was passed before the memo of appeal and connected IA was served to the appellant. Also, there is no specific prayer for status quo, either in main appeal or in the IA. Further, no order has been passed in the IA. Two things emerge from the aforesaid paragraph. Firstly, there is violation of natural justice as the learned court has not afforded a reasonable opportunity of hearing which has the potential of resulting in miscarriage of justice. Secondly, the learned court has granted relief to the appellant without there being any specific prayer and pleading to support such prayer. Further, it appears that the appellant is only carrying out agricultural activity and if that be so, there is a possibility of irreparable loss which cannot be compensated by monetary damages and which has no adverse bearing on the respondent. In view of the above, the order it is so and so passed by the learned civil justice is suspended until further order and notice was issued to the respondent. My lord, may I submit, my lord, one thing, my lord? Civil Judge Senior Division had passed the order, my lord, when our caveat was in place, my lord. Without hearing the caveator, my lord, status quo order was passed and we were directed nobody should enter the land. So on those grounds, my lord, fundamental grounds that caveat application was there, we were not heard. Even the order also reflects, the civil judge order reflects that the caveator was to be served copies after the order was passed. So we challenge all those aspects and we challenge those aspects under 15.2 of the Arunachal Pradesh Civil Code Act before the learned district judge. And this was the order. And we are in possession of the land, my lord. There is an LPC in my favor. And we have been stopped from entering into our own land. And there is an agricultural activity which has been done by me.
What is to be done?
My
That
lord-
party is not there.
My lord,
Your Honor, my lordship, I'm appearing for the petitioner.
Yes, so,
But we are not ready for the hearing.
huh?
Ready for the hearing since the conducting counsel is Sharma is party based and today he is absent.
So what can we do? It is listed for hearing and
Yes,
yet the interim order is in your favor.
Yes.
So,
My lord, we all receive, my lord, we are also not,
Adjournment for today.
we are not agreed by the interim order also. We are agreed by the order of this DC, my lord. Whether he has,
do you challenge that?
lord.
File an application in that case, if you are not agreed by the order of this court.
My lord, in the text of the order, my lord, he has passed this order. This
So how can we do unless it is brought before on record? If it is, unless this is bring on record
yes, my lord.
or brought on record, what can we do?
But the interim may not be extended, my lord, because it was still returnable date. My prayer would be there.
This is unnecessary, it will create a complication. We'll hear the matter, dispose of the matter. My name. All right.
My lord, I am not being able to enter into my own land, my lord, because of this status quo, my lord.
That we are not here. Whether the learned district judge has passed the interim order correctly or not, we'll see. Which what we are not going to decide here.
My lord,
You agreed? You agreed to any date?
my lord, in the morning also I have asked whether they are going to do the matter. They said that they are going to do the matter. They have.
Yeah, we
they
will
could have-
appear, but
They could
for
have told us
hearing
in
we
the
are not
morning
ready for
itself.
that. We said we will appear, but for hearing we are not ready.
We appear and we will not do hearing. That is something which I have not also heard, my lord. Yes, they will do the hearing. They have said so.
It's okay. We're not going to all this.
And my lord, my agricultural products, my lord, all these are very.
Sir, we're not going to decide all these things. We'll in this petition, whether the learned district judge has legally, passed the impugn order correctly or not, that we'll examine. Who is what, we're not going to examine. It's a civil revision petition, right?
Yes, yes, my lord.
So, it cannot be casualist, madam.
Yes.
Better is listed for hearing. Either you take an adjournment in the beginning or now also you have to take an, if you're, the council has some difficulty, you just cannot. He's right. This is something you have to understand.
Yes, Your Worship.
He has asked you whether the case will be, I mean, whether you will do the case or not. You said you will appear. Then you argue the matter. We'll hear you. We have time. Sorry. Yes.
Kindly Lordship, matter will be adjourned for today.
Huh?
Kindly adjourn the matter.
So when?
Can it be on 38th of this?
Huh?
38th.
30. Yes. As agreed to by the council for the parties. This on 30.
Yes, madam.
04/20/25 for him. Huh?
But till then, interim shall be continued.
Huh?
Interim will continue.
We are not continuing the interim. Let's say. Let it continue. Interim of the person.